Well, good afternoon, everybody. Welcome, and thank you for coming to our session, which we've sort of renamed the yin and yang of the U.S. legal system. This is the bringing essentially offshore claims in the U.S. in an onshore jurisdiction. But I use yin and yang for a reason, which we'll get into. Let's start with if you're old enough to remember the Admiral Stockdale moment, who am I, why am I here? For those of you who don't know me, I'm John SABLONE. I wear a bunch of different hats at Nixon Peabody. I'm the global commercial practice group leader for the firm, so we have about 300 litigation attorneys across the empire, which I'll show you in a minute. But I also, more importantly, there is a subgroup of those litigators and dispute professionals in the team that I chair, which is our private fund disputes team. So we represent many of the offshore liquidators and others in the offshore world, as well as onshore entities, and basically any type of private fund dispute, or quite honestly, almost any type of financial services dispute. With me today is my associate Christopher Queenan, sitting directly to my left, and also in our commercial litigation practice group. And then to his left is one of my associates, Eric Walls, who sits in what we call our government investigations and white-collar defense group. And I won't bore you with all the Nixon Peabody slides other than to say, when I talk about the empire, this is our empire. We are essentially a U.S.-focused firm. We have major practice groups and offices on both the East and West Coast, as well as in the Midwest and Chicago, and then some global offices in London, Beijing, Shanghai, Hong Kong, and most recently Singapore. I also want to throw a special thank you to David Marchand for putting us yet again right in front of the cocktails, because I know how much, I think half the crowd has already left for cocktails and the other half will probably be out of here in a half hour. So
I have one underneath my desk, John.
You have one there? Good. I hope you all brought your own cocktails, because we're gonna go. Actually, it's the best time of the day, right? So let's get started. Why do we call it the yin and the yang? I want to talk about two different types of jurisdiction in the U.S. The first is going to be civil jurisdiction, and we'd like to discuss some of the benefits of civil jurisdiction in the U.S., especially for foreign and offshore claims. It's an area we've talked to our clients a lot about. It's areas we've litigated and handled many times, and there are lots of benefits to the U.S. legal system when it comes to bringing foreign claims in the United States, whether they're, again, offshore or international in general. The yang part comes in, and I wanted to throw that in because more and more we are getting queries from our clients in the offshore world related to possible criminal investigations and regulatory compliance investigations in the U.S. And so the yang part of this is, while we're going to give you all kinds of great tips as to why the civil jurisdiction in the U.S. can be so broad to bring these types of claims that we're going to talk about, the flip side of that is that the criminal authorities in the U.S. have an equally broad perspective when it comes to whether or not they can reach international actors and bring them to trial in the United States for crimes committed under the U.S. Code. So broad jurisdiction generally, good on the civil side if you want to bring claims, maybe not so good on the criminal side if you want to avoid being in a U.S. jail. So let's talk a little bit about the civil side. And for those of you who practice offshore or in any of the Commonwealth jurisdictions, you'll recognize some of these benefits. The first is the liberal pleading standard. And this is something that took me a long time as an American litigator to get my arms around with respect to the Commonwealth system, because here we have this incredibly liberal pleading standard. It's notice pleading. The complaint that you file can be exceedingly bare bones. It just has to lay out the claims. And we use wonderful phrases like upon information and belief. So, as Chris knows, upon information, I can allege that upon information and belief, Chris Queenan is a fraudster. And that type of allegation in the UK or any of the Commonwealth jurisdictions, especially offshore, would be met with incredible disbelief. Our foreign clients say, how can you say that? We need 18 specific causes of proof, and we have to lay it out, and we've got to do a year-long investigation to show what we can do. No, in the U.S., We have notice pleading, and therefore it is upon information and belief, blah, 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 blah. That allows us to bring claims in the United States when we know that something has been going on, but we can't exactly figure out the specifics, the who's, the what's, the whys. We can at least allege that a fraudulent scheme or some other activity has been going on, and it is usually enough in the United States to avoid what we call a motion to dismiss, what the Commonwealth courts might call a strikeout motion. So it's a very, very important concept because it allows you, it gives you access to the court system here where you would be denied access essentially in one of the other jurisdictions. And that theme of access is going to keep popping up over and over and over again in this presentation because at the end of the day, despite all of the flaws, and we're going to talk about some of them, the U.S. legal system in terms of access to the court system is far superior to anything in the offshore world or in the Commonwealth jurisdictions.
Excuse me,
yeah, go ahead, Chris.
The one thing I would add to that, there is one slight exception to this liberal pleading standard, as there always is one exception, and that's obviously when you allege fraud, and typically in these types of cases, we do bring a claim for fraud, and in that case, you are supposed to, and you should provide the who's, the what's, the when's, the where's, and the why's to the extent that you can.
Right. Well, even then, when we talk about fraud, there's a rule in the U.S. You have to plead fraud with particularity. The particularity standard is still nowhere near the English or Commonwealth standard. It is, I don't have to have actual evidence of it. I just have to be able to say specifically what I think the fraud is. Upon information and belief, Chris Queenan is a fraudster. Upon information and belief, Chris Queenan did all these bad things, and that's specifically what the fraud is about. And so, again, I don't have to have actual evidence of it. I have to allege it with particularity so Chris knows what it is. So
I know what it is, by the way.
You know what it is, yeah. And you're going to see how the pleading standard fits in with some of the other things we're going to discuss. Second most important issue, the so-called American rule, which is pay your own way. We have the English rule and we have the American rule when it comes to how legal fees are handled in litigation. And as many of you know, in the English system, the loser pays, for lack of a better way to put it. I've been astonished at my work in some of the offshore jurisdictions where it's not just the loser pays, it's this ongoing tally of who is paying for which motion and who is paying for which decision by the court at every step along the way. And we're having a discussion with an attorney from the Isle of Man at lunch, and it gets in the way. You can argue the merits of both systems, but the loser party pays is a detriment to actually settling litigation. Because once you think, if I take this to fruition and win, I'm getting my legal fees paid, it cuts against the notion that I should compromise the claim and try to resolve it. In fact, it gives every party incentive to push forward on the notion that I might actually win this and then I'm going to be made completely whole. Also in that construct is this notion that and I love every one of them, but all of my offshore lawyer friends, attorney friends, do get into this mindset of, this motion is being brought, this is what's going to happen with the fees, and sometimes we talk about the tail wagging the dog. The fees end up being the biggest issue being litigated over time, and in my view, from my very American-centric view, it's a distraction. The dispute is not about who's paying whose legal fees. The dispute is about the problem at hand, and if you're worried about who's paying whose legal fees, that's only a problem created by the litigation. It's an ancillary, a secondary problem. So the American rule here is actually quite nice, which is, depending on which side of the V you're on, essentially with some exceptions, as Chris would probably say, everybody pays their own legal fees. So even if I have certain types of claims, even if I bring them to trial and win, I'm not getting my legal fees in recovery. And therefore, it creates incredible incentives upon the parties to reach a compromise, to try to settle the case. Easy example there, I had a client in the UK, was an aerospace company in Hampshire, and they had a claim against another contractor, and they spent six figures, around 100,000 pounds in legal fees, just trying to get the issues marked up for a case. And at the end of the day, it was going to require a very large bond be posted. It was going to require, another 100,000 pounds in legal fees just to get the ball rolling. And they were frustrated. And that entity, the company they were going to sue, had a parent here in the U.S. So instead, we brought suit here in the U.S., we filed a bare bones complaint, and we settled the claim within a month. for not the full amount, of course, but a substantial sum which made them close to whole and which avoided years of protracted litigation and the idea that someone's going to pay somebody else's fees and we're going to get caught up and we have to post a bond. So again, the access point is important. The other issue with the American rule on access, and it doesn't get talked about a lot, is we hear words like champerty, we don't really know what they mean. Those are for law school exams. As many of you know, in the U.S., we have contingency fee arrangements, which are perfectly ethical. We've done some of them. We don't do a lot of them, but in the right circumstance, a contingency fee case can make a lot of sense. And again, as a way to get access to a court without having to have the fees up front to pay the lawyers, especially if you're dealing, and we do it many times, you might be dealing with a liquidation offshore. That liquidator may have a valid claim against a party in the U.S., but the fund in liquidation may not be able to pay fees up front. And that's a situation where we'll work with the client, sometimes have a contingency, sometimes have some type of a hybrid contingency where they're going to pay some amount of fees by the hour and then some as a percentage of the recovery. But much more flexibility in terms of fees and the way they play out in cases. Broad discovery. This is one that many of you I know like about the U.S. and fear about the U.S. at the same time. As the slide says, just don't call it a fishing expedition, right? But discovery versus disclosure is, sort of like a filet mignon versus chuck steak in terms of the information you can get and the quality of both. I've been involved in many cases in the UK and offshore, and let's forget the continent for a minute. We'll just focus on the Commonwealth system. You can get very, very limited information and disclosure. The U.S. discovery rules are completely different, as many of you know. They allow for broad-ranging discovery, and not just discovery of paper material, but discovery of electronically stored information, what we call ESI. And those types of discovery rules are incredibly powerful when you're the plaintiff in a case in the U.S. So let's go back to my liquidator example. You're a liquidator sitting in the British Virgin Islands or in Cayman, and you have somebody in the U.S. or a company in the U.S. you want to bring a claim against. Number one, you're not as concerned about the legal fees because you may have to pay them or you may have a contingency arrangement, but you're not worried about paying the other side's fees too. Number two, we can start the complaint with a broad-based notice pleading. And number three, once that broad-based notice pleading is filed, we have access to this incredible discovery rules in the U.S., which allows us to go out and find all the information that actually fits our claim and would allow us to win. And sometimes it's the mere threat of that discovery that makes all the difference in the world. So you can't look at each of these in a vacuum, but when you put them together, they are incredibly powerful tools, and the discovery tool is probably the most powerful. And just to give you a sense, the electronic discovery piece, this is something that's been popping up a little bit in some of my cases offshore and in the UK. We have the ability to go and get native files, to get metadata from servers from other parties in a case. What that means is I may not just be able to get an email, I can get the metadata related to that email, which would tell me who it was sent to, who it was forwarded to after the fact, who was the last person to open it, who was the last person to print it. What did they do with it? Metadata from a Microsoft Word document includes things like all the changes that were made to the document. Even if you weren't tracking changes, they can tell us which computer made which changes to a document. So real benefits that would be key in a contested case that you can get in the U.S. and you really can't get under the disclosure system. You can try, but you wouldn't get as much. So something to think about in terms of the discovery piece.
If I could just add on the predictive coding point there, you saw at the very bottom, that's something that's really exploded in the United States legal system in the past couple of years, and it's something that has been used in the actuarial sciences, financial services industry for a while. And just briefly tell you what that is. It's really a computerized system combined with intelligence, with a human expert that can predict results. So when you're dealing with this vast amounts of documents, and you really don't want to have an attorney going through page by page to determine if it's relevant to a discovery response, whether it's relevant to your case, if it's a key document. Basically, a computer will do it for you. And the way this works is you'll have an attorney go through a fair number of documents and say, yes, relevant, no, not relevant, yes, relevant. And the computer learns, the system learns from that, and over time it'll develop its own algorithm for what's relevant and what's not, and sort of spit it out to you. So you don't spend all this money on legal fees, having people like me sit there in front of documents for hours on end. And usually the tipping point for when it's worth to invest in that sort of technology versus when it's just worth to have someone like me go through those documents or someone else is probably about 100,000 documents is where you reach that tipping point.
Yeah, we've used it more and more. By the way, just quick show of hands, because I love interaction. Who in the room even knows what predictive coding is? Oh, okay, good. Hey, we're doing pretty good. We've been using it more and more. The courts in the U.S. have been accepting it more. I mean, we didn't get into it, and it's too detailed for this presentation, but when you get into the electronic discovery issues, the plus side is you get all this wonderful material. The downside is you get terabytes of all this wonderful material you have to sift through. And what predictive coding, as Chris said, allows you to do is, maybe review 5,000 documents in a data set and have that data set, those results then be have an algorithm apply those results against 10 million documents and do all that work for you. So again, tools and predictive coding and all kinds of computer-assisted review have been accepted by the U.S. courts in a way that, again, you don't see in the disclosure world as much. So another benefit.
And a year ago by the U.K. courts too.
Yeah, well, so the UK courts are a little dicey in terms of it made a lot of news that there was a predictive coding case that came out of the UK. I'm not sure it's really been as broad-based accepted in the UK as we were led to believe when it came out. But part of the problem, again, is you have to get the court to sanction you to go out and collect all of that data and information, which, again, becomes kind of the problem. Before you can have a problem that requires predictive coding, you've got to have a court order that allows you to go collect all that information, and harder to get in the Commonwealth system. So this one we debated this slide a bit because this is certainly not the purpose of litigation, but one thing that's very different in the U.S. compared to other systems is the public nature of our trial courts, or our adversarial system. And we said airing opponents' dirty laundry for leverage. That is to say, in many instances, the settlement, a settlement can be reached by the fact that a party does not want allegations in a publicly filed forum against them. And they get around that in the offshore jurisdictions because those allegations are not public for the most part, and they can't be disclosed. And I've seen orders come out of Cayman where parties have been sanctioned and other things if they try to do that. Here, for the most part, every single court is open to the public. Every document that is filed with a court is available for inspection by the public. And certainly in the federal system, and now in almost every state system, you can go online and pull anything you want off an online docket. So if I file a complaint saying that Chris is a fraudster, the whole world can access that complaint. And it may very well be that Chris doesn't want that allegation out there. It may very well be that there are specific allegations in that complaint or in a document that is filed with a court that Chris doesn't want the public to see. And again, in the offshore jurisdictions, Chris can be fairly certain it's probably not going to get out, but in the U.S., it is going to be public. David Marchand and I were having a discussion during one of the breaks, and he made the comment that a lot of the offshore courts, value privacy, what he might say privacy, and that's probably true. There's much more of a privacy element to the offshore litigation world than there is in the U.S. In the U.S., courts are supposed to be open to the public, so all the hearings are open to the public, the documents are available. The only way you get around it is if you can file something under seal, and judges take a very jaundiced view if you're trying to file too much under seal. So sometimes public pressure can help resolve a claim, and you don't get that same pressure offshore or in other jurisdictions as you do in the U.S. We're not going to get into all of them, but you've heard a lot. There are other benefits. You heard a lot about litigation financing. I won't talk about it, but that's another avenue that I know especially many liquidators have used for claims in the U.S. over the past few years. We're going to talk about jurisdiction in a minute, but the use of the New York banking system as a jurisdictional trap is something that really makes a difference. Jury trials. Pretty much in the U.S., you are guaranteed, for the most part, a jury trial, even in civil claims. So if you're dealing with a fairly bad actor on the other side, it is incredibly useful to have not just a judge adjudicating a specific contract provision as you would get in Cayman, but having a jury sit and listen to the evidence and determine not just the facts, but be able to weigh credibility. So if you do have a bad actor, having that jury system in place makes a huge difference and can really tip a case. And then we didn't talk a lot about it, but the liberal and expansive application of the law is a fancy way of saying most U.S. judges are going to try to do equity, and they will oftentimes bend the law to fit the bad facts of a case, where my experience offshore has been that just does not happen. For example, we had a case we brought in state court in New York, and the parties essentially had to agree for the most part that Cayman law would apply, even though we were trying the case in New York. But we had the benefit of a New York judge trying to apply Cayman law. And, the notion, there must have been, affidavits and declarations stacked to the ceiling from experts on Caymanian law and how, the claim should be dismissed under Cayman law because it went outside the four documents outside the four corners of the document. But that's just not an American judge's mindset. And he did what most American judges did, which is he punted. He basically said, I'm not sure yet, so I'm going to allow the case to proceed. Well, once he allows the case to proceed, we get those broad-based discovery opportunities, and the case eventually worked its way to resolution. So something to think about in terms of, even if you're applying another jurisdiction's law, the prism through which an American judge might view that case or that law is very different than in Cayman or in BVI or in the UK. So let's talk about jurisdiction. All this sounds wonderful, except how do you get into the U.S.? If you're sitting in Cayman or BVI or Bermuda or wherever, how do you get your case into the U.S.? And that comes up, there's this concept of minimum contacts, which we won't delve too deeply into. But here's the bottom line. If you can allege some type of contact with the U.S., it's usually good enough. So we've got two types of jurisdiction, general and specific. And on the general, it doesn't apply to most of the cases we see, because there you have to show that the defendant you're suing in the U.S. Is essentially doing business in the U.S. on a regular basis, and it would be fair to have them be subject to the jurisdiction of the courts. That's not really the case in most of the offshore matters that we see. Rather, we fall within the specific jurisdiction requirement, which is that the defendant's contacts demonstrate that there was purposeful availment, essentially, of the underlying forum. Let's talk about, before we get to Chapter 15, purposeful availment. Chris is going to talk in a little bit about the New York banking system. But one of the issues we're going to circle back to is the ability to bring claims in the U.S. where foreign parties have used New York clearing banks for transactions. And there's been recent case law in both directions on that point. But, good onshore counsel can craft a case that can probably stick if somebody is using a clearing bank or even a bank to house funds in the United States.
Yeah, I mean, there was, at the end of this past year, in November or December, there was a decision in New York State Court that got people sort of excited in this area because a correspondent bank was found to be enough to bring personal jurisdiction on an entity. And in that case, it was a Saudi oilman who was going after a Swiss bank in connection with a alleged kickback and bribery scheme with the oilman's, the Saudi business owner's employees, and it was a drilling company. And essentially what happened was alleged was that the Swiss bank was complicit in this by setting up a BVI company in which to route the payments from this. And these were kickbacks between the employees and vendors of the drilling company. And what was alleged to have happened was that these payments were routed through a New York bank, a bank account held by that Swiss bank. And the question was this enough for jurisdiction? And the court said yes. And some people saw this as a reverse on 20 years of jurisdiction in New York, because usually the court holds that it's not enough just that money passively goes through these correspondent bank accounts. It's just wired through. And I think the court was motivated because the complaint in that case alleged wrongdoing by the Swiss bank, that they were sort of complicit in this activity, that they set up the BVI company, and that they knew what was going on. We spoke too soon, and about a month ago, there was a decision in federal court in SDNY, Southern District of New York, where the opposite result was reached. In that case, it was a group of investors in a BVI fund, and they brought claims against foreign HSBC entities, alleging that these entities were provided them services in connection with the Bernie Madoff fund. And in that instance, they found that just because HSBC routed money through an account in New York into the fund was not enough to bring jurisdiction on these HSBC at foreign entities, and that there needed to be more. And it is tough to reconcile those two decisions, and the court tried to do it in the latter case. And it basically, I think, turned again on the fact that that the Swiss bank was heavily involved, and they actually brought direct claims against the manager, the customer relations manager at the Swiss bank, and sort of had specific allegations about he knew or should have known about the kickback activities. And that was something that was sort of missing in the latter case.
Yeah, and I think that is the way to reconcile them. These cases sort of turn on, okay, if I just took some activity and used a correspondent bank in New York, that's one thing. But if I was using that correspondent bank in New York in order to further a fraud that I knew about, that might change the analysis, because as a practical matter,
right,
now you're taking advantage of the forum state, here in this case New York, to continue with this scheme in the American sense of the word scheme.
And I will also say, and it's still, that New York decision, that state court decision, is still helpful, because it does talk about it. This is a very heavily factual inquiry when you're looking at whether this is enough, these correspondent bank accounts and just money being routed through. So that gives you another tool, if you have a good faith basis, of course, to allege that the entity you're interested in going after knew or should have known about this, and that allegation might be enough to withstand a motion to dismiss, or at least get jurisdictional discovery. And jurisdictional discovery can be a very useful tool to sort of dig in to see what's really there.
Right. I mean, the discovery rules, even if a court says I might entertain this motion to dismiss for lack of personal jurisdiction in a case, the courts oftentimes will allow limited discovery on just the jurisdictional issue, and that can make a big difference. So let's talk for a few minutes about alternatives to pure litigation. What we've been talking about so far is I am a foreign entity and I want to bring an affirmative claim in the U.S., or maybe I'm sued in the U.S. There are two other tools that are used primarily by offshore funds to access the U.S. legal system. The first, I know many of you are familiar with, is Chapter 15 of the United States Bankruptcy Code. And I'm going to let Chris talk about Chapter 15, but before I do that, let me just say that this is a very powerful section of the Bankruptcy Code, and it can be very useful, but it is limited to the insolvency context. So that's kind of an important distinction here, right? We're talking here about the U.S. Bankruptcy Code being used when essentially you've got an offshore liquidation. If we're dealing with a run-of-the-mill civil claim, Chapter 15 is not going to help you. So you got to remember this is in the insolvency world.
Yeah, and if you go a couple slides, there's the Helis case.
Yep.
And the Helis case just showed how powerful this tool could be for a liquidator. In that case, the Southern District of New York actually allowed the liquidator to bring a claim under Section 423 of the United Kingdom Insolvency Act. And the defendants there, yelled and screamed and said, there's no way they should be able to bring this claim, because the U.S., in their view, didn't have jurisdiction, because that claim says that a UK court can only issue an order in connection with that. And the court sort of disagreed, and they said that they read that section of the UK law as procedural and not substantive. And they thought that we're a U.S. court. We adjudicate non-federal claims all the time, including claims overseas, and we have the ability to analyze whether or not this claim has been violated. Ultimately, it was dismissed, and this is also instructive a few years later because they brought the identical claim in the foreign liquidation. And the defendants there said, well, they can't bring the same claim in both actions at this point. In that case, the court looked at it again and said, well, if you're going to bring these in both jurisdictions, we're going to dismiss it here because the UK court would know better than us.
Yeah, you can only imagine what the English judges thought of the New York judge applying the UK Insolvency Act. So there's a question, I think, in the corner of it.
There's also a weird law case with the public trading and cable law. Was permitted, not granted any law, so
Right.
not really complete, but it's the same issue.
Right.
Whether or not a U.S. court could adjudicate because the statute itself gives as well as the court says the court, what's the court mean? Does that mean the foreign court or the court? I think it's also a default issue on some of the statutes that are drafted.
Right, and there were a bunch of cases out there. You probably noticed I skipped by Fairfield Century because, frankly, most people in the room probably know much more about Fairfield Century than we do. We've been involved, but there's so much is well known about it. I think, to me, the way I think about Chapter 15 is that I think of it almost like a mini hotspot. You can set your phone up to be a Wi-Fi hotspot. That's a Chapter 15 claim. You're basically lodging jurisdiction in a specific court in the U.S., and the center of main interest is somewhere offshore. And that little hotspot, whether it's the Southern District of New York or the Southern District of Florida, wherever it's going to be, acts as a place where you can then reach out into the U.S. in different areas. So you're not bringing individual claims everywhere. You establish your hotspot, your Chapter 15 filing in one place, and then from there you can do all kinds of funky things throughout the country. Again, though, only in the insolvency context. The other area, which I love and I find amazing, and I think a lot of the offshore lawyers know about it, but it's not very well known either within the U.S. or among a lot of other foreign lawyers, is 28 United States Code Section 1782, which many of you probably just hear referred to as Section 1782. This is a statute that provides access to the U.S. discovery tools without actually filing a case in the U.S. It's an effective tool for liquidators especially, but really, again, remember, Chapter 15 insolvency, 1782 could be anything, so it's not just liquidators. You could have a contract claim in Cayman and try to seek discovery in the U.S., and we'll talk about that in a minute, but it applies to all claims, not just insolvency claims, and it can be very cost-effective and efficient. What is it? It has three main requirements. The person from whom discovery is sought has to be reside or found in the jurisdiction of the court here in the U.S. Well, what does that mean? Well, maybe some documents were transmitted to the U.S., and those documents are sitting on a computer server in New Jersey, or in New York, or in California. Maybe you're dealing with a director, or an officer, or a fund manager who happens to live in the United States. It can be any combination of documents or people. As long as the person or the material is found here, and it may be relevant to, we're going to get there, to the foreign proceeding, you can use 1782. I telegraphed the second requirement. The discovery must be for use in a proceeding before a foreign tribunal. So that's a pretty easy, should be a pretty easy prong to meet, because if you think about it, the only reason I would want the information is it has to be somehow related or relevant to the proceeding in Cayman or BVI or the UK, and therefore it's going to be for use in that proceeding. And then the application has to be made by an interested person as related to the underlying foreign proceeding. I can't just decide I'm going to file a 1782 application as a reporter, for example. But if I'm a party in a case in an offshore jurisdiction, I am an interested person and I can bring the claim. And then once you file it, the court looks at a few discretionary factors. And one of them is whether these documents are testimony. And testimony is key. A lot of our foreign clients want to use 1782 to get documents, it's the entire discovery panoply. So you can use 1782 to take the deposition of a witness who's physically resident in the United States or present. That's critical, right? You don't get deposition discovery typically, or at least broad-ranging deposition discovery in other jurisdictions. So documents or testimony are within the foreign tribunal's jurisdictional reach and thus accessible. For the most part, that's not the case, but obviously if that witness or those documents are within the reach of the foreign court, you don't need the U.S.'s help. So that would be a factor that cuts against it. The foreign court or government would be receptive to U.S. federal court assistance. That's one that's always kind of dicey. I always...
I mean, we have had success,
We
I think,
have.
in some cases, actually having the foreign liquidation court actually issue an order or authorize expressly the use of this tool.
Yeah, what we've done in the past, we've done it a couple of times. One time we did it in BVI, where we actually got the court in the liquidation proceeding. We got the judge to actually sign off on the liquidator pursuing a 1782 application in the U.S. So it happens. Again, typically most foreign courts are receptive if the litigant or the liquidator in the offshore jurisdiction can demonstrate that the material is important. 3, the Section 1782 request conceals an attempt to circumvent foreign proof gathering. Again, you can't use the United States as an end run around. I mean, if, for example, a foreign court rules that some information is not admissible or not relevant or not material, you can't then run to the U.S. to get the same material. You know, you have to live within the confines of the orders that are being issued by the foreign court. But again, in most cases, that's not a problem. And then lastly, if the subpoena contains unduly intrusive or burdensome requests, well, unduly intrusive and burdensome is in the eye of the beholder. And so typically we can work around that piece. Bottom line, courts continue to hold that a foreign bankruptcy proceeding is within the scope of 1782, and a liquidator can use 1782 to seek discovery relating to third-party claims, even if those claims must be asserted in action separate from the insolvency proceedings. What that means, by the way, is that, and Chris is going to talk about a case, you know, we can use 1782 discovery sometimes to follow a money trail. We had a case recently where the 1782 materials recovered identified that while there was a BVI, while money was lodged, allegedly fraudulent monies were lodged in a company in the BVI, we could use 1782 tools to figure out that the vast bulk of that money actually sat in New Zealand, and you can use it to help trace the money.
Yeah, and the cases that are coming down are still supportive of these sort of efforts and these liberal discovery efforts. The only thing that's up in the air with 1782 at this point, I shouldn't say the only thing, but one thing up in the air at this point is the use of it in international arbitrations. The circuits are sort of up in the air of whether or not that's permissible, but there are arguments to be made that it can be used.
Yeah, and we have the same issues in the United States with respect to arbitration and whether just broader discovery can be used in arbitration, because there the parties have contractually agreed to limit the scope of what the tribunal can do, and you don't necessarily immediately get access to everything under the discovery rules. So let me wrap up on the civil piece before we turn to criminal. One thing I want to point out is, at least in the U.S., the goal in some of these cases is not always cash. We've used litigation as a tool, and we think in the U.S. as litigation as a business tool. Sometimes that means we can get enhanced liquidity into a fund by bringing an action. Sometimes it means we can get, through negotiation after bringing an action, reduced to deferred manager compensation. Sometimes we can get independent valuations. We can get a negotiated liquidation plan. Redemptions in kind, where maybe the fund manager wasn't permitting those before we brought a case. Take over control of a fund. There are oftentimes levers within the fund documents that allow for step-asides and push-outs and other replacement of managers that we can do. And also we can sometimes force officers, directors, and others to actually discharge their fiduciary duties if they've been asleep at the switch. So don't always think about litigation in the U.S. as a money-making process. Sometimes it really is a business tool to achieve something that's not monetary, but provides pressure to negotiate a better deal, even if that just means for better transparency into a fund or a deal that you didn't know about. Considerations, we've been through these, we don't have to go there, and we've talked about the takeaways. So let me stop for a minute and switch gears. We've talked about the yin and the yang. So we talked about the yin, all the wonderful things you can do in the U.S. and how you get into court. The downside of this is that the Department of Justice and many of the alphabet soup of agencies, from the IRS to the SEC to others, use the U.S. criminal laws or even regulatory laws to reach people outside of the United States. And I know from speaking with many of you that this is a real concern, especially in the offshore banking world, because it's one thing to try to be sued in the U.S. and for somebody to recover money from a fund or from a defendant. It's another thing for somebody to be put on a list and the next time they step into the United States be arrested and tried with a crime. That's not fun. And it ruins people's days. So, you know, the criminal piece of this is something to consider when you start to think about, oh, this is all great that the U.S. has these broad-ranging laws. Bottom line, the criminal laws can reach you, not everybody in this room, but can reach many people in the offshore world. We have a number of laws, which Eric will run through in a minute, that sort of deal with non-resident foreigners abroad. And in certain instances, those non-resident foreigners may act entirely outside the United States, but still be held criminally liable in the United States. And the way we get there, the way the Department of Justice and the courts get there, is whether there's some connection between the criminal conduct and the territory of the United States, and there are sufficient minimum contacts. As an example, things like the same correspondent banks we've been talking about on the civil side, if you're running a fraud and you run those funds through a U.S. bank, that might be enough to grab jurisdiction. And the easy examples are things like money laundering, you know, drug proceeds, prostitution rings. You can engage in those activities completely outside the United States, but if you're running the gains from that illicit activity through a New York bank, you might be subject to criminal liability.
So one of the things we talked about earlier, one of the concepts being the liberal pleading standards in a civil case is equally as important to the criminal realm. So, for instance, the DOJ, whenever they are investigating or indicting somebody, usually it's a one-sided investigation, one-sided presentation to a grand jury, and their indictment only needs to meet the elements of a crime. There does not need to be too much of a particularity argument or presentation in an indictment. So to the extent that the liberal pleading standard is helpful in the civil context, it's also a little bit scary from a criminal context. If you're able to get a prosecutor who's creative enough to come up with a crime, they're able to get through a grand jury and actually indict you or a company.
Yeah, and the penalties are pretty severe. We're talking about, in many cases, 20-year prison sentences. And what makes this even more scary is, unlike a civil case where you're going to know that you're being sued, in the criminal context, long before a charge is brought, there's an investigation going on that you probably know nothing about. What brings them on? Whistleblowers go to the DOJ and can get investigations launched. Competitor complaints, newspaper articles, journalistic investigations. The Panama Papers is a perfect example we heard about earlier today. Direct foreign criminal investigations, spin-off investigations. So, you know, I've got one where we represent an Asian entity that had invested into the U.S. The fund was a fraud. The SEC did their civil investigation and was able to claw back some money. But then once they were done, the Department of Justice got involved. So the civil piece was over from the SEC's perspective, but the DOJ now comes in and opens a criminal investigation, and it changes the entire context of what's going on there.
Yeah, and it changes before the referral gets made to the DOJ. One of the things that you really need to be careful of whenever you're involved in SEC or other sort of FinCEN or other investigation is that you put in this dichotomous situation where you have to decide, am I going to plead the fifth and have that used against me in the SEC proceeding, or am I going to speak to the SEC, have the SEC turn that over to the DOJ, and have it used against me in a criminal proceeding? And that's a difficult call to make. A lot of white-collar defense attorneys sort of walk their clients through that or try to walk back any sort of investigatory demands by the SEC, or even put stays on SEC proceedings and try to get the DOJ to move first. And even at times the DOJ wants to have that happen. So there's a lot of strategy that goes involved whenever you have parallel criminal and civil investigations involving the SEC and DOJ that you and your attorneys need to be aware of.
Yeah, and let me focus on one. We're not going to go through every single slide and every single statute, but let me focus on one bullet here, which is the border searches or domestic search and seizure warrants. This is something that's been in the news more lately. The law hasn't really changed, but the enforcement and the scope has really been ramped up, it seems, ever since the Trump administration took over, and that is this notion that foreign travelers arriving at customs in the U.S. are going to be searched. And not just searched, but their cell phones are going to be seized, and they're going to be asked to display the contents of those cell phones, or their laptops, their electronic devices. That's something that it was legal. It is still legal, but it wasn't being done that much. It's being done a lot more. And so I don't like to put the fear of God into people, but you need to start thinking about, when you arrive in the U.S., when you're sitting in that customs hall, you're in, the proverbial no man's land. You're not in the United States yet, and therefore you essentially have no due process rights, for lack of a better way to put it. And the government can do whatever it wants to in terms of reviewing material you have with you, whether that material's in a briefcase, in document form, or on a cell phone. And we've seen that more and more. You also see it with respect to Department of Justice investigations, where if they're trying to get the cooperation or testimony from an offshore witness. We had a client in BVI that the Department of Justice wanted to question and essentially put him on a watch list because he didn't want to cooperate, where he was basically told, if you step foot on U.S. soil, you're going to be arrested. And that lasted 6 months to a year, and try getting anywhere from BVI without stepping foot in the United States. It's hard. That takes San Juan off the table, that takes Miami off the table, that takes New York off the table. To get anywhere required days and days and days of travel. So something to think about in terms of, we don't think about it very often, but just making a transit through the U.S. Could be problematic if there's a criminal investigation going on. We talked about parallel proceedings. There's also these legal assistance agreements between various jurisdictions. They exist, for example, with BVI and Cayman. FinCEN, for example, has a memorandum of understanding with Cayman that facilitates the investigation of financial transactions initiated or routed through the Cayman Islands. And there are oftentimes aggressive joint investigations. And anecdotally, it seems that the offshore jurisdictions have been cooperating a lot more in recent years with the Department of Justice. While privacy is a big issue, I think some of the jurisdictions were concerned as being seen as essentially havens for illicit conduct. And more we're seeing joint investigations and cooperation from the Caribbean jurisdictions. So we talked about the border searches, and by the way, there is a recent case, which is United States v. Levy, which have upheld that, and that was husband and wife traveling from Panama through Miami, and they were the target of securities fraud. And so you don't think of securities fraud as something that's going to get you arrested at an airport and convicted and thrown into a U.S. jail, but it can. So you need to be careful. The other reason the U.S. prosecutors tend to like to bring these claims, and one of the reasons why sometimes the foreign jurisdictions play along, is the difference in punishment. I find this slide sort of fascinating in that when you think about the base U.S. punishment versus the baseline U.K. punishment, 25 to 30 years compared to 10 in the U.S. for fraud, money laundering, 20 years in the U.S., 10 years in the U.K. And frankly, the U.S. prosecutors enjoy better resources in some respects than prosecutors abroad. For those of you who dealt with the U.S., there's never enough money that can be spent on throwing people in jail. So you need to be much more careful, and if you are pulled in one of these webs, the danger that you're going to spend substantial time in a United States prison is pretty high.
Yeah, that's one of the things that we've seen often representing our clients overseas is that there's oftentimes an investigation that begins in a Western European country or China or other Southeast Asian country that within a short period of time is referred to the Southern District of New York or to the, in our case, sometimes the Boston U.S. Attorney's Office or elsewhere for a sort of parallel criminal investigation. And that was precisely the reason. The criminal punishment here was so much more severe than the forum that the wrongdoing, the majority of the wrongdoing occurred, that it puts a lot more pressure on that particular defendant to plead or to resolve the case early.
Right. Also, I just wanted to point out the Yates memo. Some of you may know that term. It refers to our former Deputy Attorney General, Sally Yates. And this has to do with individual criminal culpability for corporate wrongdoing. You know, many of us think about corporations as having their own existence, and they do, and for civil liability, that's the case. But what the Yates memo did was sort of institutionalize this concept that individuals are going to be responsible even when there's corporate wrongdoing. And as she said in this memo, quote, "Only by seeking to hold individuals accountable in view of all of the factors above can the department ensure that it is doing everything in its power to minimize corporate fraud and over the course of time minimizes losses to the public through fraud." So something to think about. This was a memo that came out in 2015. Some of this, I think, was frankly in response to the fact that we had the biggest global financial meltdown in the last 100+ years, and basically, as they like to say, almost nobody went to jail. There was lots of civil lawsuits and lots of clawback actions and lots of bankruptcies, but nobody went to jail. So this was a symbol that the Department of Justice was going to start looking to individuals, and those individuals can be offshore. And you can read the key points of it. It goes beyond that, but it will seek to hold individuals accountable. And most importantly, I think that the way it's going to be enforced is obviously through all the tools that we've heard about. And then once the Department of Justice has all this information, you know, they're going to start looking to individuals. And those individuals can be subject to jurisdiction on the criminal side in the United States.
And for those of you who, if anyone in here represents offshore companies or even investigations here in the United States, one thing that the Yates memo does is it puts you in a tough position of figuring out when it is that your employees are going to need independent counsel. So oftentimes when you are representing a company, you can keep the employees under your own advice and counsel because you're all aligned. Well, the Yates memo sort of flips that and puts the company, makes the company adverse to his employees to the extent that the employees had any wrongdoing. So whenever you're involved in an investigation, an internal investigation or a DOJ investigation, it's important once you're in the U.S. to keep sight on when it is that you're going to need to refer your employee to his or her own counsel for purposes of sort of separate representation.
Right.
And the other thing I would add is the Yates memo is not something that's just out there and it's a feel-good sort of thing for prosecutors. We do see actions being brought by the U.S. Attorney's Office that would not, against individuals that are very aggressive and would not have been brought years ago.
Yeah, and if you're wondering, well, what's Trump think of all this? The answer is, for the most part, the new administration seems to be standing by some of these tough criminal constructs that have been put out there. And I think it kind of fits in with this notion that we're certainly going to hold wrongdoers to account, especially foreign wrongdoers. So we don't see, again, anecdotally, we don't see this changing under the new administration. We think the enforcement is, if anything, going to get more severe. We're not going to get into the specific, because we don't have enough time, into each specific example, but the big one that comes up a lot is what we call the FCPA, the Foreign Corrupt Practices Act. And this one's key because it's sort of the quintessential example of where you would think a U.S. court was reaching to hold people accountable, because you can have essentially offshore or foreign activities that ends with somebody being in jail. So Eric, you want to just run us quickly through the FCPA?
Sure. So the FCPA, as a lot of you might know, was at least denounced by Trump, but at the same time has been recently, I guess, reinvigorated by statements made by the DOJ that they're going to enforce it, they're going to look to use this as a tool. So the FCPA essentially criminalizes foreign bribery as one aspect, and a second prong is the accounting provisions and internal controls provisions. And what the bribery prong criminalizes is the giving of something of value. It can be anything from one of the most recent examples are things like unpaid internships. No money was changed hands, but interns were hired by a particular company that were the sons and daughters of a sovereign wealth fund directors, managing directors, and because of the relationship between their interns and the government, the United States government took the position that that was something of value that was given to a foreign official for the purpose of getting more business out of that particular entity. So it's read very broadly, but like I said, essentially it's giving something of value to a foreign official for the purpose of getting business. Now, one of the more interesting pieces of the FCPA is that though it has the words Foreign Corrupt Practices Act, the extent that it reaches abroad is sometimes less than other statutes. So the idea of something called extraterritoriality, which is a longer word than I'm used to saying, applies with equal force to the FCPA as it does to other statutes. Essentially, the idea is Congress has the ability to enact laws that reach overseas, but those statutes will be read as though they only apply to domestic conduct unless it's explicit that they apply to foreign conduct. So in this particular instance, the FCPA applies to domestic companies, U.S. citizens abroad, and then foreigners who act while in the United States or direct their conduct to the United States. So it's a somewhat of a limiting framework in that it doesn't cover all bribery overseas, but it's certainly broad enough that if you have money flowing from one entity through your company that is a bribe of some sort, that it might be able to reach that conduct.
Right, and just to point out, one of the example on the bottom is important, which is you could have, and this happens regularly, right? You can have an offshore fund, you could have a meeting in New York City, and depending on where a director lives or how that meeting took place, what was discussed at that meeting, that could subject you to criminal culpability under the FCPA. Although I want to take Eric's point well, which is, other statutes essentially do the same. I talked about money laundering earlier. The activity can happen purely in a foreign jurisdiction, but if the illicit gain is run to the United States, that might be enough. So there is an FCPA pilot program which encourages cooperation and self-disclosure, and that's something some of you may hear about occasionally, which is if you're an attorney and you're investigating something within a client and you realize something may have gone awry, there are benefits. Talk to your trusted onshore lawyer about this stuff. Don't make your own assumptions, but there is a pilot program that tries to encourage self-disclosure and cooperation. We talked about money laundering, and let's just focus on a couple of takeaways before we turn it over. Just remember that the U.S. criminal statutes aren't limited by your business's presence in the U.S., whether that business is a fund or offshore company or whether it's an actual operating business. And you need competent criminal defense attorneys. It doesn't have to be us, but it should be somebody. In fact, we've been hired in many instances where offshore or foreign actors think something may be going on in the U.S., think there could be an investigation, think that the elements are there for some type of investigation or proceeding, and they've hired us and others. And we can sort of start digging in, talking to people within the DOJ and getting a sense of whether this is something that's a real possibility or just a fear. And remember the focus on individuals. With that being said, I'm going to ask if anyone is brave enough to ask a question 4 minutes before cocktails start. Oh my God, two right there. Kerfuffle.
And it's under appeal, so I just thought that would be interesting.
Yeah, and we have a lot of cases with Canada and the interplay between the discovery rules, and they are more different, I think, than people realize. And I always like the idea of getting the foreign court's sign-off before bringing a 1782 application, just because it gives you cover, right? And it mitigates that prong where a court in the U.S. has to make a decision about whether this would work.
Well, the suggestion was that even if we had comments in advance, we wouldn't have met pre-action discovery test. So it's like, the standard is never being applied prior to get any investigatory
Right,
background in the U.S., whereas before we were able to.
right. There was another question in the back, yep.
Technical against from video analysis. Could you just comment quickly, you touched on it more there, but takeaways about the potential for 1782 where it's in contemplation of proceedings rather than actual proceedings, and difficulties with that?
Yeah, and I should call on my Toronto litigator here. Yes, you can use 1782 in that manner. The problem with that type of discovery is it becomes harder to meet each of the prongs. You know, if you think about it as I have a case that's pending in the UK or in Canada or in some offshore jurisdiction, and we're in the midst of disclosure, and I know that there are documents or witnesses in the United States that are highly relevant to what I want to do. It's a pretty easy, and I use that word, you know, carefully, but a pretty easy lift to get a judge in the United States to say, yes, this makes sense. If you're talking about pre-investigation type issues, there you are, you're asking a U.S. judge to make a lot of determinations that could cut against the factors we discussed in 1782. And one thing I didn't mention but should have in 1782 is when you bring the petition, the other side is not necessarily involved in that. You know, many times they are because there's an ongoing case and they know you've brought it. But most times, the other side or whoever you're trying to target doesn't have notice of the 1782 petition. Sometimes they get wind of it and show up. But I think my experience has been that judges, even in the U.S. and even under 1782, they struggle with granting a petition where the other party's not there. And in the pre-investigation situation, that's much more typically the case than in after the fact. It doesn't mean they don't grant them. It doesn't mean they don't go forward with them. It's just, it gives them some pause. So yes, to answer your question, it can be done, but it has to be buttressed much more substantially with why this is important and how it fits, as opposed to if you've already got a foreign court sign-off or you've got an action in a foreign court where it's pretty clear what the issues are. And that's something, you know, we do those on a case-by-case basis. We take a really hard look. And sometimes it'll depend on the jurisdiction. Remember, 1782 applications, unlike my Wi-Fi example, my hotspot in Chapter 15, 1782 applications are brought in a specific district, and you know, different districts have different, they're all following the same discovery rules, but some of them have different perspectives on how far they can reach. And just to give one last example on that, you know, foreign discovery from a 1782 application sometimes come up. We had one where the entity was a large consulting firm in the U.S. that was the target of the 1782 application, but a lot of the material we were actually looking for was in Bermuda. So you've got a BVI litigation seeking 1782 discovery in the U.S., and some of the documents are in a subsidiary in Bermuda. And you know, different jurisdictions will view that differently, this notion of custody, possession, or control in the United States of when you can get discovery. Some jurisdictions and some judges are much more likely to say, you have access to it, you can get on your laptop and view that document, you're going to produce it. Others are much more likely to draw that line between the corporate forms and the different jurisdictions. So it all plays in. It all becomes much harder in the pre-investigation piece, and it all plays into what type of, how you frame your petition, where you bring it, and what your request is in terms of the types of material you're looking for. Any other questions? It's cocktail time, sorry folks. Thank you so much.